Hello and welcome to today's webinar, which is Unlocking Justice Alternatives, Restorative Justice Conferencing with Adults in the Criminal Justice System. My name's Catherine Gorder and I'm your facilitator today. I'm very sorry that I'm off screen and you can't see me. We're subject to technology limitations here, but great to have you along today. I'm going to start with an acknowledgement of country. So Legal Aid Queensland acknowledges and respects the First Nations custodians of the lands where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders' law, customs and creation spirits, and we recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role First Nations people play in our community and in improving our legal system. So yes, today's webinar is Unlocking Justice Alternatives, Restorative Justice Conferencing with Adults in the Criminal Justice System. I'm joined by two presenters today, Andrew and Emma. Thank you so much for joining us today. So Andrew Robinson is Convener Adult Restorative Justice Conferencing in the Dispute Resolution Branch at the Department of Justice, and Emma Yates is also a Convener in the same branch. Thank you both again and welcome. We have a little bit of housekeeping to do this morning before we kick off with the presentation content. So just to remind you all that this session is being recorded and that the laws and content are accurate on the day of the live presentation and are subject to change. There's more information about our CLE resources on the Legal Aid website. You can go to the CLE page and find out more about upcoming webinars and other resources we have available. If you have any IT technical issues with the webinar, unfortunately, we can't help you with that during the live webinar, but if you contact the GoToWebinar customer support, they may be able to help you. So we have a 1 hour webinar today. It will include approximately 40 minutes of presentation time and we're allowing up to 20 minutes for questions. So you may see on your screen, there's a little area where you can type questions. So I encourage you to type them in during the presentation and we'll take a look at those. We have got two handouts available for download. One is a copy of the PowerPoint slides from today and another is a handout for stakeholders. So you can get copies of those from the handout section on your screen. And we'll kick off with our first poll for the day to learn a little bit about who's joining us today at home. So our first poll is, what region do you work in? And I'll just launch that for you now. So the options are Southeast Queensland, Far North Queensland, Regional Queensland, and outside of Queensland. So I'll give you about 10 seconds to choose an answer, and then we'll share the results with everyone. So far, Southeast Queensland is looking like the highest proportion joining us today. A couple more seconds. I'll close that off and share the results. And yes, we have about 75% of people joining us from Southeast Queensland today. Welcome. We've also got people from Far North Queensland, Regional Queensland, and no one interstate today. So it's all Queenslanders today. So that's great. So now I think we've got one more poll after this. Yes, the next poll is, what is your role? So I'll just switch to that one and launch that. So we'd love to know a little bit about who's in the audience and joining us today. So the options are support worker, financial counsellor or health education worker, social worker, lawyer or other. So again, we'll give you about 10 seconds to answer that poll. Couple more seconds. Okay, I'll close that off and share the results. So most people are from the other category today. Welcome to you all. We've also got about a third of everyone attending as lawyers and 10% support workers. So thank you. That's just really helpful for us to know for our presentation content. I'll just close that poll now. Okay, so moving on to our next slide, I'm now going to hand over to Andrew and Emma to start their presentation. Thank you.
Thanks very much, Catherine, and thanks, folks. It's lovely to be here today. In today's presentation, Emma and I are going to give you some information about adult restorative justice conferencing. So we'll inform you about what that is, what the benefits of adult restorative justice conferencing are, as well as what matters can be referred, what are eligible, how we assess for suitability, what outcomes can be facilitated in a conference, what happens in a conference, and how people can access ARJC. Thanks, Catherine. And Emma, over to you.
Thanks, Henry. So this video, Carmen and Roman's restorative justice experience, unfortunately we can't share that today, but if you download the stakeholder kit, there are links to 5 or 6 short clips that are on YouTube that show a whole range of different aspects of our process. And Carmen and Roman were a couple who actually came through our process and they tell their story. So I'd encourage you to have a look at that in your own time. But adult restorative justice conferencing is basically a facilitated process that brings together the people directly impacted by a crime to have a conversation, to discuss, to address what happened, who's been impacted by the harmful actions and how, and what's needed to make things right or to repair the harm. So many of you, of course, are aware that the criminal justice system thinks about crime in terms of rules and punishment. If a person has committed a crime, is there evidence? Are they guilty? And if they are, how should they be punished? And a victim of that crime has very little say in the outcomes or even often very little participation in the whole process. So restorative justice, on the other hand, is really focused on the people involved and on the harm that's been done. The process is absolutely designed around the needs and wishes of the person harmed or the victim. So we talk to people about what are your justice needs? What are your healing needs? What would meaningful justice look like for you in all of your circumstances? It's also really important that it's not just a case of get in a room and say sorry. It's a process that absolutely requires the person responsible or the defendant to be genuinely accountable, to take responsibility for what they did. And we're talking about harm, so the idea of acknowledging wrongdoing. Our guiding principle is do no further harm, and we'll talk in more detail about how we assess suitability and what that might look like. It's also important that it's a voluntary process, so for a referral to be able to be made to us, both the victim and the defendant need to consent to that referral. Thanks, Catherine. It's also a confidential and privileged process. So under the Dispute Resolution Centres Act, all of us who work for adult restorative justice conferencing are legally required to maintain confidentiality. It's also a privileged process, so anything disclosed or discussed in the process can't be used in any kind of later legal proceedings. And there are real benefits to that. We are very much trying to create a safe space, a non-judgmental space, where people hopefully feel free to be as open and honest as possible, to take responsibility, to apologise. Really, it encourages truth-telling. So there are significant benefits for a person harmed. I might just say something about terminology quickly. So you will have probably already heard I'm clicking between different language. So in restorative justice, we tend to talk about the person harmed and the person responsible, but we're also very aware that in the criminal justice system, we talk about complainant, defendant, victim, offender. So we'll probably flick between that different language today. So for a person harmed, having an influence over the outcomes is a real benefit. It's also a chance to tell their story and the opportunity to really determine what is or isn't discussed. And this is one area where we know that restorative justice aligns beautifully with what's needed for trauma recovery, because when someone's been harmed, typically that incident has taken away their choice and their control. And restorative justice, this process really gives back to that person far more choice and control over exactly what the process is going to look like, who's going to be involved, what's going to be discussed or not discussed. So for example, if they don't want to retell their story because that would be re-traumatizing, they don't have to. They can choose what is discussed and what isn't discussed. It's also a real benefit is obviously that it's about holding the person who's harmed you accountable to your experience of what happened. It's actually having acknowledgement of the harm that's been done and hopefully a genuine and meaningful apology. And we know that those things can go a really long way in terms of healing and closure for people. One of the hardest things we hear a lot is that it just didn't make sense, and that can make it very difficult for someone to move on. So hearing from the defendant some kind of explanation of what led to their behaviour, so getting a better understanding of the causes of the behaviour and the opportunity to ask questions and have those questions answered, often to hear that it was not a targeted attack, it was random. All of those things can really help to reduce fear of re-victimisation and also give closure. And as I've already said, you know, acknowledgement and apology are really significant. Thanks, Catherine. So for a person responsible, there are also real benefits. Most of our referrals come from police or prosecutions, and they are diversionary referrals, which means that if the matter is able to be resolved through our process, then charges will typically be discontinued. So for a person responsible, that's a very significant benefit. There's also a real benefit in terms of making things right, not just with the person you've harmed, but also with yourself. So the opportunity to get a better understanding about what led to your actions and to consider how you might avoid reoffending. Often people say, you know, that was completely out of character. I want the person I've harmed to understand that that's not the real me. I'm not that monster. So that can be really important. Getting a better understanding from the person harmed about how they've been impacted is important and can allow the person responsible to really be able to apologise in a meaningful and significant way, which helps that person as well. And it's also far less stigmatising than the criminal justice system because we focus not on the defendant, it's not about punishing the defendant, but we focus on their behaviour. So making that distinction between not judging the person, but asking them to be accountable for their behaviour. Thanks, Andrew.
Thanks, Catherine. There are also benefits for the community at large, and those are in the main simply being involved. So allowing the broader community to be part of a process that responds to crime. It can also help give community members a better understanding of the cause of crime, a better understanding of the impact of those crimes, provide support. So oftentimes at a conference, we will involve support people. So they could be you know, people's loved ones, or also a broader community of support. And so it allows those agencies to be involved and provide direct support to the participants of the conference. And for the justice system, it can also mean reduced caseloads going through court. There can also be an increased satisfaction for defendants and victims participating in our process compared to, say, a court process. We also find that because the outcomes facilitated in a conference are decided by the people attending, we have higher compliance rates. And of course, there's, you know, a good body of evidence out there about a reduction in recidivism associated with restorative justice processes. Catherine. So to be eligible for a conference process, there must be an offence against a person which has caused some sort of interpersonal harm. So we need a clear victim or victims and clear defendant or defendants. To be eligible, a referral also needs to be received from a justice agency, including Queensland Police, so operational police, prosecuting authorities, so that could be Police Prosecution Corps or the DPP, and as well as courts. We can also accept referrals from victims, or that a referral has come from a formal agreement. For example, we have an interagency agreement with Queensland Health supporting a project that they do. But in the main, those are where our referrals come from. Also, to be eligible, the referral and the parties involved can be reasonably serviced from one of our locations across the state, and importantly, that all parties consent to the referral.
So Andrew, can you just explain a little bit about the kinds of matters that we often see? What are the kinds of charges that come to us?
Yeah, that's a good one, Emma. Usually they're some sort of physical assault. So I think still our highest proportion of referrals involve assault occasioning bodily harm, but they can also include really serious forms of assault, like grievous bodily harm, wounding, but also sexualised and domestic violence offences, as well as property offences, and I guess crimes of dishonesty, such as, you know, fraud or stealing.
And is there any sort of restriction in terms of at what stage of the criminal justice process we can take
referrals?
referrals?
No, there isn't. So we can actually accept referrals at any stage of the criminal justice process, including pre and post-charge referrals. So if an operational police officer believes they have enough evidence to charge somebody but doesn't necessarily want to go down that route, they can refer a pre-charge referral to us. But we can also accept post-sentence referrals, and those types of referrals usually deal with you know, historic types of offences. So they could be, you know, historical sexualised violence offences. Yeah. Thanks, Catherine. So as I mentioned before, we can accept sexualised violence, domestic violence, and also offences where there are children complainants. We refer to these matters as being high risk because there is a higher level of risk for practitioners to involve. So for sexual and domestic violence offences, there should be appropriate supports in place for the participants, and that adult restorative justice conferencing in those cases for sexualised violence also provides a consent information session to help prepare the defendant for participating in the conference. As I mentioned, we accept referrals for child complainants, and in those cases there must be an appropriate representative for that child, and that representative consents to that referral. So we're talking about you know, a parent or legal guardian acting on behalf of that child. That representative should also be able to canvass the child's perspective and wishes without causing any further harm. And it's important for us in the carriage of those matters that we understand whether child safety has been involved and what their views in relation to the referral are as well. So they can also include a higher level of collaboration with other agencies. And in some cases, higher risk matters, because of their level of complexity, can take you know, a little bit longer than, say, an assault or say a property offence. Emma, I think you have an example of a high risk matter, don't you?
Yes, yeah, thanks, Andrew. So I guess I just wanted to speak a little bit to the domestic violence referrals as well. It's important to understand that we don't take referrals of domestic violence order situations. So what we're talking about is domestic violence charges. And, you know, with those, we're really, really mindful of that additional layer of risk and safety assessment that, you know, any one of us, any practitioner would be doing in those sorts of matters, even over and above our usual framework of do no further harm. So we really like people actually to have a domestic violence order in place. That's often really helpful. We don't get many referrals for intimate partner violence matters. We do them, but we don't get many of those. And when we do get those, we're absolutely looking not just at the incident that's been referred, but also getting a history of the broader domestic violence context so that we can really assess, looking at safety and power dynamics and all of those things about whether our process is going to be suitable. But so more commonly than intimate partner violence, we get mainly harm within those broader family relationships. So, for example, between siblings, sometimes intergenerational harm, so what you might think of as elder abuse kind of cases, and also quite a few parent-child cases where a parent's assaulted a child, and that's then comes in as a DV referral. And we know that in those family contexts, often the person harmed absolutely wants accountability and justice, but doesn't necessarily want the criminal justice system involved in any significant way. And it's often really about relational repair as well. So just as an example, I had a case with two brothers. One had assaulted the other and was charged. So the defendant was using ice at the time of the assault, and that did contribute to his behaviour. When I spoke with the brother who'd been assaulted and their father, it was really clear that their main concern was the ice use. And the brother really didn't feel safe at home any longer. And he was also, he had a physical disability, and that was kind of, I guess, adding to his feeling of not being safe at home because of the mobility issues. They were very concerned that something like this could happen again. So when I spoke to the defendant, by that time, he told me he was no longer using, but he agreed as an outcome of our process to participate in a 6-month relapse prevention program. But perhaps most importantly, he had no understanding of how unsafe his brother and father felt at home as a result of his behaviour. And so it was important for them to be able to talk about that stuff in the conference and do some of that relational repair as well. Andrew and I also worked on another case together that was a referral from the Child Protection Unit, and that was a pre-charge referral of a young man who had sexually assaulted his much younger cousin. He had an intellectual disability. Both families were extremely close. There were really significant ripple effects of harm across that extended family network. And her parents, again, absolutely wanted him to understand the seriousness of what he'd done and to be accountable for that, but saw no benefit in him being charged. And we were able to run a really powerful and restorative process with the families.
Thanks, Catherine. So in 2023, June 2023, as a result of a successful funding bid, we in ARJC were able to expand to what is now a statewide service. And we have physical staff located in Brisbane, Gold Coast, Toowoomba, Mackay, Rockhampton and Townsville, Cairns and the Sunshine Coast. But those staff, while they're physically located there, can cover the whole state. And the way that we might be able to do that is by using technology such as Microsoft Teams for conducting intake appointments and conferences where appropriate. We also have some capacity to travel to other sites on occasion for in-person appointments such as intakes and conferences. In those circumstances, we would probably try to use a magistrate's court location. Yeah, so this expanded capacity means we can accept referrals from any location in Queensland. Catherine, thank you. So what makes a good referral? Like anything, we need the right ingredients. So it's important when considering whether a referral to our service might be a good idea that all parties consent to engage with ARJC, that those parties agree on the basic circumstances of what's alleged. So, for example, that the defendant isn't using it as a platform to negotiate their level of responsibility, that the defendant or person responsible is able to take a suitable level of accountability for their actions, and that there's been enough harm for those people to want to invest time in our process. So what I mean by that is we've found that, say, for a shop stealing offence where somebody has stolen a $13 bottle of wine from a BWS, that we have had challenges in getting that chain to invest time for such a small outcome. So there is actually some good evidence out there that suggests that the higher the harm, the greater potential there is for reparations to be made. The other ingredient is that the defendant's willing to take steps to repair some of the harm that they've caused, and that the parties referred are willing and, I guess, ready to participate. We know that in some circumstances, for example, immediately after an incident of harm, it might take the complainant some time to process what's happened and to be ready to participate. Thanks, Catherine. Emma, over to you.
I was just going to speak briefly to a road rage
yes, of course.
that was actually probably one of the first cases I was involved in, and I think of it as kind of the gold standard in terms of what made it. It was a really good referral. So, as I said, it was a road rage incident. The victim was a 62-year-old woman, the defendant a 40-year-old man, and he was charged with willful damage and stealing. So, in a nutshell, she was driving home along a busy road in the late afternoon. At a point where the dual lanes needed to merge, she sort of nipped in front. She acknowledged that she probably cut it a bit fine. I think she might have waved. He honked. She gave him the finger. But basically things escalated, and he then threw something at her car. She heard a loud bang, was frightened, pulled over to check whether there was, what kind of damage there was to the car. And he then pulled over as well. And I know she told us that as soon as she noticed he'd pulled over, she was fearful about, what could happen next. They had a verbal exchange, which did get a bit escalated, and basically it culminated in him leaning across, grabbing the keys out of the ignition of her car and throwing them some distance into the bushes on the side of the road and then driving off. So by then it was getting dark and she couldn't locate the keys. She wasn't able to move the car. It was peak hour traffic, other cars were honking at her, and she described being really, shocked and frightened, and she was sobbing. She was very distressed. So what made it a good referral? When the police spoke to the defendant, he spoke to them voluntarily, and he took full responsibility. He was sad, he was remorseful, he really wanted to make things right. There was also enough harm for her to want to invest in the process. So the damage to her vehicle, the cost of panel beating was about $800, and she did want him to pay for that. But more significantly, she had been really terrified by his actions at the time, and she just couldn't make sense of what he did, just why someone would do that, and particularly why he would leave her on the side of the road in that vulnerable way. And she had to drive the same route home every day, and she was unable to put this behind her because she kept on reliving the experience every time. So she really wanted a sincere apology to make some sense out of what had happened, and she wanted reassurance it wouldn't happen again, as well as the cost of repairs. She was also quite reluctant to meet with him because she felt afraid of him. So when we spoke with the defendant, he was very open about the fact that there had recently been a death in his family. His mental health was not great and he was really struggling, and he was able to explain all of that, but significantly for him it was an explanation, not an excuse. Notwithstanding that she might have given him the finger or any of those other things, he was absolutely taking responsibility for his actions and for the harm done to her. His description of what happened also aligned really closely with her description, so there was no disagreement about what had happened. He'd done quite a lot of reflection already on how she might have been impacted. He could understand that she would have felt attacked and vulnerable. He had a lot of empathy for her, so he really got it. And he was very keen to meet with her, happy to answer questions, really wanted to apologise. He had also already sought counselling to address some of those other things that were stresses that were going on for him. And that was important in terms of him being able to actually reassure her that something like this wouldn't happen again. So basically, he was able to meet her needs in terms of what she needed to repair the harm. And once we were able to explain all that to her, she was reassured by that and agreed to meet with him. And we ran a conference, and you and I did this one as well, didn't we? With her and with him and with her daughter came as a support person. And yeah, it was a fantastic process. And they both expressed afterwards that they felt that they now could move forward, and it had been very helpful for them. Thanks, Catherine. Oh, sorry.
Oh, you want to go back?
Yeah.
No worries.
I was moving track. So what might make a matter unsuitable? I guess it's basically the flip side of what would make it suitable, but it is important. We always explain to people, even if you both want to come through this process, we still have to make an assessment about whether it's suitable or not. And there are things that we absolutely need to look at. So, you know, how much the stories need to line up really depends on what the person harmed needs. But if for either person there's a significant difference and they really want there to be some kind of absolute establishment about what happened and there's a dispute about that, then it needs to go to court. It's not suitable. Whether or not the person is being sufficiently accountable, again, there's a spectrum of accountability. So it's really about what the person harmed needs. But we know that if that person is engaging in denial or victim blaming, or really seeking to excuse their behaviour, then that's going to be harmful for a person harmed to hear any of that and really adds another layer to the trauma. So we would really look at that and either say it's unsuitable or how can we adapt the process. So in a recent case, a father had assaulted his teenage daughter. He had a fairly low level of accountability, but she wasn't expecting a lot from him, but she really wanted him to understand how she'd been impacted and she wanted an apology. And as conveners, we have done quite a lot of work with him in terms of growing his insight into his own behaviour and also how she'd been impacted and his level of responsibility. But when we spoke to him just days before the conference, it was clear that he just flipped very readily back into a kind of a victim blaming her, she triggered him, you know, those sorts of statements. And ultimately we felt that it didn't matter how carefully we tried to structure a conference, there was too great a risk that he would do that and that would be harmful for her. So in the end, we discussed it with both of them and we went ahead with the daughter writing a victim impact statement, which we then still met with the father and we shared her statement with him. And then he agreed to provide a written response and she had particular things that she wanted him to address. And that written response also comes back through us. So if there's anything in that response that we think may not land well, we'll then do a bit more work with that person before we forward the response on. So we try to manage things so that matters can go ahead if possible. The relationship between the parties obviously is also significant. So any concerns about coercion or intimidation or a balance of power that we can't manage in the process. And that also includes the idea of free and voluntary consent. So if a person's consenting, but actually they're really scared about what could happen if they don't go ahead with this process, then we would probably say it's not suitable because it's not a freely given consent to the process. Thank you, Andrew.
Thanks, Catherine. So what are the possible outcomes of a conference? They can range from apologies, which can take the form of a verbal or written apology, or perhaps even a statement of remorse or some sort of a commitment not to reoffend. We also facilitate financial compensation. And when we refer to compensation, we mean a payment which is based on the victims of crime Assistance Act. So there is a schedule within the Victims of Crime Assistance Act which provide amounts payable in accordance with the offence. So that's what we mean by compensation. The other sort of payment that we can facilitate is restitution. And what we mean by that is it's a payment that covers an expense that's directly arisen from the incident itself. So say, for example, in a property related offence where there's been damage or something stolen, we can facilitate payment or for a reimbursement of either, say, a repair bill or a replacement item. It's important that in those circumstances where we are facilitating a restitution payment, that the complainant is able to substantiate that. So if someone's wanting a restitution payment for an actual expense, then we'd ask them to show us, say, receipts from, say, a counsellor or a medical bill or, a repair bill or something like that. We can also facilitate charitable donations. Sometimes it's important for a victim of crime that the offender addresses the underlying causes of that crime. And what that can look like is, in some circumstances, a victim might ask an offender to attend some sort of behavioural change program or counselling or rehabilitation. But while those are probably the main sort of things that we can facilitate, we can facilitate other things within reason, provided that it's directly linked to repairing the harm and it's meaningful to the parties. And it can also be reasonably facilitated by us. Yeah, thanks, Catherine. So what happens in a conference? It's important to understand that a conference can be a really flexible process, and practitioners often put a lot of thought into designing a process that meets the specific needs of the complainant as well as the circumstances. So this could take many forms, such as a face-to-face conference, a telephone conference. We might use MS Teams. In some circumstances, we might be able to conduct a shuttle style conference where one party's in one room and the other party's in another, and we might go between those rooms. We don't tend to do a lot of those, but we can. And in some circumstances, the victim might want the process to proceed, but they might not want to have, say, an in-person or direct involvement. And under those circumstances, we might be able to collect a statement from them, which we would read on their behalf to the defendant at the conference. Sometimes a complainant will send a representative to speak on their behalf. And of course, the conference convener can sometimes conduct conferences on their own, but in some circumstances, for balance or in complex matters, they might choose to bring in a co-mediator just to help them deliver the conference more effectively. So there are many variations. At the conclusion of the conference, we usually send the parties away with something in writing, and we refer to that document as being a restorative outcome plan. So it's a document that reflects the agreed outcomes. So it provides all of the details that are necessary for, say, the offender to be able to fulfill whatever commitment that they've made, and any other details that might either be symbolic or otherwise. But the important thing is that parties have something tangible that they can reflect on. Now, following the conference, if there are tangible outcomes, say, for example, the offender's agreed to make a payment or they've agreed to participate in counselling, we can only monitor that outcome for up to 6 months from the date of the conference. So it is time limited, which means that any outcomes we are facilitating need to be completed within that 6-month time frame. Yeah, thanks, Catherine. So how can people access ARJC? So for a victim, they can self-refer, and the way they do that is by contacting our service either directly themselves or by asking either an operational police officer or a prosecutor to refer a matter to us. For offenders, while they can't directly refer themselves, they can either ask an operational police officer or a prosecutor to refer a matter, or ask their solicitor to approach the prosecutor and have a referral made that way. It is important for us that in some offences there could either be bail conditions or some sort of an order, like a domestic violence order. In those cases where there is such a thing, we may need to have those conditions varied to allow the parties to meet in a conference process. Otherwise, we'd be facilitating a breach effectively. Yeah. Thanks, Catherine.
I just wanted to add quickly, because we're aware that there are quite a lot of lawyers online, but obviously for all of you, this is fantastic information that you can give to anyone accessing any of your services, any of your clients. For lawyers particularly, we know that you play a really important role in terms of helping people to decide whether this is a process that they want to participate in or not. So we'll often say to a defendant, you know, go and have a chat to your lawyer about your options. What's it going to look like for you if this matter continues down the criminal justice system track as compared to coming this way? So having a good understanding of what the alternatives is important, and also preparing people to be able to participate meaningfully, you know, answering any questions about what the process could involve. So that's an important role that you play.
So I can't believe we're already at the questions section, which is great. So this is an opportunity to ask any questions of our presenters while we've got them here, and I encourage you to do so. We haven't had any come through yet, so just while we're waiting, I can skip ahead and run through some other slides, but I was just going to ask about timeframes, and I was looking back through the slides. Is there any, I mean, I guess it might change client to client, but what sort of timeframes would someone expect, like once they've had a matter referred to the ARJC, what might that look like?
Look, that's a good question. We do have KPIs for that. So our timeliness KPI is that we must try to complete 70% of referrals in not more than 65 days. And, you know, so while that's the maximum length that we try to facilitate in, it may not take that long. And so since we've been able to expand our service and recruit more practitioners, we've found that our timeliness has improved significantly. So there isn't any waiting list for our service. And
that's fantastic.
It is, it really is. And you could expect that, you know, within a week or so of having your matter referred, you would expect to hear from a convener. And of course, there are exceptions to that as well. I think earlier in the presentation, when I was talking about high risk referrals, for example, or any matter that has significant complexities, you know, it could exceed those time frames.
Sure. Yeah. No questions yet. So you can still pop something in the question box if something comes to mind, but I'll just move on with our slides and I'll keep track to see if there's any questions that come through. So we did have a link here if people wanted to subscribe to your newsletter. So did you want to say anything about that newsletter, or?
I think this is a fairly new thing for us. We're sending out a newsletter about monthly. It's not long, it's a really quick read, but we're just sort of sending out updates of any changes, just a reminder really that we're there and how to refer to us. So if you scan on that link, you can sign up for that. Yeah, and we would love you to do that.
And we can include that link to subscribe in the email that we'll send to everyone who's registered for today's webinar when we share the recording afterwards. So if you don't grab that link now, we'll share it again at a later date. and also your contact details. So they're the best way to contact you guys if someone's got a referral.
Yeah, absolutely. Reach out. We're more than happy to spend time speaking to people who are interested.
Yeah.
Great. Well, it looks like we don't have any questions, which may mean you've answered everyone's questions in your presentation, so that's great. So I'll move to wrapping up and just share a little bit more information about what's coming up for our next webinar. But you've got a couple of minutes if you still have a burning question. Oh, we've just had one come through. Somebody has asked, how effective is the process with youth?
Well, that is something that we can't really comment on because referrals for young offenders are handled by a different agency. And so while I understand that it's still predicated on the principles of restorative justice, there may be some variation because of complexities associated with working with young people. What I'd encourage you to do is either reach out to Youth Justice Conferencing or to Google it. There is a good body of research around restorative methodologies in the youth space, and it is generally thought to lower recidivism.
Great. While we wait for more questions, I'll just pop through the next couple of slides. So I'm just sharing here the key contact information for legal aid. If you have a client with a legal issue or you know somebody who needs some legal information, they can call our phone line, which is the first one there, 1300 65 1188. And what we say is anyone can call that phone number and get free legal information, anyone in Queensland. That phone call is not means tested by any means. There's also lots of great information, legal information on our website. So anyone can call that phone number and get help with a range of criminal law, civil law, family law, legal issues. So that's our key phone number. We also have a priority phone line for First Nations people. And so those calls to the 1300 65 0143 number are answered as a priority in the call queue, ideally by one of our First Nations staff members. So we encourage First Nations people to use that phone number. The other number we have is for people who have submitted an application for legal aid and are querying the status of that or have some further questions, and that phone number to call is the 1300 383 900 phone line. As I just mentioned previously, the legal aid website, it has stacks of really useful legal information resources. We have probably over 80 brochures, self-help kits, fact sheets, wallet cards. You can read all of this information online and you can download or order them and they will be sent to you for free. So they're free delivery and free publication. So if your organisation frequently uses or downloads legal aid publications, just know you can order hard copies of those for free to be delivered to your organisation at no cost. So I encourage you to do that. There's also lots of web content about a range of lots of legal issues. And what we say at Legal Aid is if we can't help your client with their legal issue, we will refer you to someone that can. So please, I encourage you to get on that website and have a great look. And I'll share the link to that when we send the post-webinar email out. And our final slide for today is just to let you know about next month's webinar. So as it is DV Prevention Month, next month we'll be running a webinar on domestic and family violence pathways to safety, looking at the referral pathway arrangements we have here at Legal Aid, and that will be presented by one of our lawyers and our referral pathways officer from our violence prevention and women's advocacy team. And before I move on to the next slide, we've had another question come through. So someone has said, I am from Restorative Justice Conferencing for Youth Justice. Thanks for the response, Andrew. In addition to lowering recidivism for young people who offend, all of the same benefits for the victims apply to the person impacted by an offence committed by a young person. Plenty of evidence online to support this. So thank you for sharing, Martin. That's really helpful. If that's all the questions we have, we might wrap up 10 minutes early today, so early mark for all of you. So I'll just go back to the last slide and just let you know that a captioned version of this webinar, a recording will be made available on our YouTube playlist, and I'll share the link with that after this webinar. and I encourage you to follow us on all of our social media to find out about upcoming webinar topics. And thank you very much to Andrew and Emma for joining us today. That was really helpful. I hope everyone watching got lots of useful information. So that's it from us, and enjoy the rest of your day. Thank you very much.